Thank you, Debbie, and good afternoon, everybody. As Debbie said, we're here to talk to you about some legal stuff. You'll have heard a lot today about how technology and data analytics are transforming the world in which you work on a daily basis. Without wishing to detract from that in any way, our job is to tell you something about the regulation that applies to the information that you're using for the employees in your business. The session is entitled General Data Protection Regulation, and that's because that regulation will shortly replace the current regime under the Data Protection Act. Popular demand and data protection are phrases which I don't think I've heard go together before, but be that as it may, enthused by that, I will proceed. GDPR requires a holistic approach across the whole of your organisation, and as reward specialists, you're going to be an important part of that. You will need to have in mind a number of things which we'll come to have a look at in a moment, in deciding what information you need, why you need it, and what you're going to do with it. Very, very briefly, this isn't a commercial, I promise you, a brief word about our business so you know you can evaluate, we know what we're talking about. We are a professional services business covering all aspects of an organisation and its people, covering legal, which Sophie and I work in, people consulting and communications. So GDPR is very much a core part of our business. Excuse me. You'll be familiar with the Data Protection Act 1998. It's been around for the best part of 20 years now. What we're looking at is what will shortly replace it. The Data Protection Bill, which has gone through the House of Lords now, following its second reading, is there to implement the EU-derived GDPR, General Data Protection Regulation. I stress this is not affected in any way by Brexit. The government has made a clear commitment that it will implement the regulation come what may, and it will stay in our on our legislative book. It'll be enforced from the 25th of May from next year, so you've got a few months to get your acts together. In a reward context, it'll cover what employees get and what information you hold, which is related to or affects what they get, and that obviously will cover pay, pensions, insured benefits, incentives. It'll also be relevant to your ability to comply with gender pay gap data. Headlines. Look first at the good things. There's nothing revolutionary about this. It's not a total overhaul of the existing regime. It adds to it. It strengthens it in a number of ways. So there are similar concepts of personal data, of sensitive personal data, which they now call special categories data. Data Protection Act principles will remain. There are specific sections on data security, how you look after the data you've got, and transfers outside the EU. As we see it, it's a good opportunity to engage with your staff. If you want to be employers of choice, then the degree of seriousness you attach to compliance with the GDPR will be an important feature, we think, of employees making choices whether or not to join your organisation. There is, of course, a but. It does require a change of mindset. It's no longer a tick-boxing exercise. You're not just responding to complaints or breaches. You are required to approach this new regime proactively. If there's a breach, you'll have to be able to show that you've addressed your mind to what information your organisation needs, why you need it, how long you need it for, and what you're going to do with it while you've got it, and a plan as to how you process that information in accordance with the data protection principles. And all of that is called data protection by design, which is really at the heart of the new legislation. On to what is new. GDPR is wider in territorial scope. There are increased financial penalties. There's been a lot of publicity on this. I'll come on to that in a moment. Much more onerous accountability and governance issues. just touched on that, and a positive requirement to report breaches following the model which applies in the US. So in terms of territorial scope, if you're an EU-based organisation, it'll cover data you process anywhere in the world, personal data you process anywhere in the world. If you're outside the EU, but you process information about EU citizens, again, you will fall within the scope of the legislation. One of the good things is that if your business is present in more than one EU jurisdiction, you can choose your regulator. You can just pick one legislative regime that you think suits you best. The UK Information Commission's Office is generally regarded as more commercially focused than some in other EU countries. France, for example, has a particularly strict approach to things. Generally, the ICO will take good notice of commercial considerations that employers have. The transfer of data is still problematic. The principle remains that you can't transfer data out of the EU or process it out of the EU unless it is being done in a country with equivalent protections, and the EU Commission maintains a list of those. Or alternatively, you have adopted binding corporate rules. If the process is being done by a subsidiary in, for example, Saudi Arabia, which has very little control on this, on information handling. Or you use the EU standard clauses if the contract is with a third party outside the EU jurisdiction. We have some reservations about the binding corporate rules and the standard clauses, but at the moment that's what the Commission says you're free to use. So I think you should feel free to follow those if you wish. In terms of penalties, this is the big one really, this is the real sting. Although, as I'm sure you've all noticed, the ICO has started to impose more severe penalties on data breaches, for data breaches. Generally speaking, the consequences of breach of the Data Protection Act are more reputational than financial. No longer. Because of some of the more spectacular breaches, Uber, for example, Yahoo, Pizza Hut, harsher penalties were thought to be needed. So now, in future, the maximum fine that can be imposed on is 4% of your worldwide turnover, or 20 million euros, whichever is the higher. There are some criminal penalties in the UK Data Protection Bill relating to intentional or reckless use of pseudonymised data, or knowingly handling that data, or altering records to prevent disclosure. Again, there are more stringent criminal penalties in some other EU jurisdictions, France again being one of those. As I said earlier, this is no longer a box-ticking exercise. It's not sufficient simply to respond to complaints or breaches that come to your notice. You have to take a proactive approach to implementing this legislation, and an organisation will need to show that it's audited the data that it holds. You need to see what you've got right now, and you do that on an ongoing basis. But as soon as the legislation comes into force, you must either have done that audit or be about to do it. You have to ask yourself what of the data that's been revealed in your audit, what is needed by the organisation, why it's needed, and for how long you're going to need it, and for what purpose. You will need to conduct impact assessments to establish whether data subject confidentiality is outweighed by organisational need in those areas where there is a conflict. You may need to consider appointing a data protection officer. It's compulsory in some circumstances, depending on the nature of your organisation. But again, employers of choice would, I think, be looking to appoint a data protection officer that's assigning responsibility for compliance and oversight with one person. You will need to implement privacy by design in any new processes. So anything you're implementing into your business, anything new, you will have to have taken into account how you how you cater for data protection privacy. And that all needs to be nominally at least the responsibility of a senior board member. I will now, if I may, hand you over to the wonderful Sophie White, who will talk to you about some things which are much more relevant to your particular jobs.
Thank you. Hope I am going to be wonderful. I'll leave that to your assessment. So David's alluded to the fact that you're going to be processing an awful lot of data in a rewards function. You have to do that. You have to be providing some data to service providers to get benefits in place. And the nature of what you do is assessing a lot of incentivising rewards, which requires base data to be possibly transferred between group companies, but certainly scrutinised within your own organisation. And there's a couple of initial points that you might want to think about on that. Firstly, you need to think about whether your third-party contracts are GDPR ready. So the GDPR, in this way, supplements the Data Protection Act in that it's got much tighter rules around data processors, and data processors are people that you outsource things to. So an obvious example is an outsourced payroll provider. The GDPR extends the formal contractual arrangements, but it makes you have to put certain mandatory provisions in place. So it puts the onus on you to really scrutinise your providers. Are they people that are going to keep your employees' data secure? You need to ensure that. Do they demonstrate compliance to you? How do you check that? Are you allowed to inspect and audit to make sure that that's right? And so a very initial point that you might want to do as part of this process, once you've done the data audit that David mentioned, which is really the first step, is to think about what third-party contracts you've got. What do they say? Do they touch on those points? Some will. Some might already be ahead of the curve on this and already compliant. Some won't be. And then you need to think, how do we get them to the right place before May? And if the data processor won't engage with that, are they the right people? And do you want to be using them given your overarching requirements under the GDPR? The second point, which I'm told, again, was something that was by popular demand, is you need to be ready for data portability requests. And that's, again, a new thing under the GDPR in that you used to, as an employee, be able to request access to personal data. And that's often done in a general HR sphere in terms of employees who have a grievance, trying to get litigation ready, trying to beat disclosure. But data portability requests go further than that in that if you hold data about employees and it's not anonymised, they are able to ask for that so that they can port it somewhere else. And it has to be provided in a very easily accessible, machine-readable form. They are allowed to then retain that for themselves on a private computer. They're allowed to ask you to transfer it if you're able to another data controller, so a new employer or a new provider, if they just want to move everything into a private pension, for example. Or they're allowed to take it and they're allowed to provide it to a data controller. So you need to start thinking about how you're going to deal with that in a rewards capacity. Do you need a policy around that? Do you need to engage with your IT team really early on to work out how you manage those requests? How quickly can you get that data together? How do you get it into the easily accessible, machine-readable format? The second really big issue in an HR sphere generally, but which will definitely impact on rewards, is how we currently process data, and that's ordinarily by consent. So we see wide-ranging consents in employment agreements. We often see them in share plans, incentive plans, bonus plans that say we can process this data. There's always been a degree of caution. So the ICO office now, before GDPR, says it's not really freely given, is it, in an employment context, because the bargaining position is so unequal. So the employee has to say yes because it's part of the wider package. GDPR puts that beyond doubt. GDPR says it isn't going to be freely given and it's not valid in an employment situation. So to use it is going to be risky. And if you do want to use it, you need to do something more than what you're currently doing. You need to extract it from that unequal bargaining position. You need to have it in a separate document. You need to draw to their attention the fact that it can be withdrawn as easily as it's given, which is a headache. because how do you, if someone suddenly withdraws their consent, how do you deal with that? There's also a linked right, if you use consent, to the right to be forgotten, which is, again, you need a policy around that. How do you delete all the data you hold about an individual on their request, and how quickly can you do that? So all those things combined, in our view, mean that you don't want to, if you can avoid it, be relying on consent. You need to start looking at other ways that you can fairly process that data. And there's some obvious other grounds that you could rely on in a rewards function. So firstly, is it necessary to perform the contract of employment? That might be because there is a contractual right to bonus, there's a contractual right to some sort of incentive plan that's based on shares. Is there another contractual right? So if it isn't in the employment contract, is there an incentives plan that sits outside of that they've signed up to, and you can't actually operate that plan without processing the data? And then the other one that will be helpful to you in some circumstances is it in compliance with a legal obligation, and that helps with auto-enrolment obligations, and it also helps with gender pay gap reporting. You then get into an even more difficult situation where you're processing sensitive personal data, and that's going to be health records, criminal records. So for you, health might impact. So if you're having to send stuff to private medical insurers, the sensible thing to do would be to get very specific, explicit, and each time a separate form of consent, every time you need to do it, that makes clear what the employee is consenting to. So it's not part of the wider employment documents, it's if you want to be part of this scheme, do you consent? That's one way of doing it. If you want to avoid consent altogether, you can consider relying on one of the other fair processing terms, and that's the catchy, necessary for carrying out employment rights and obligations, and the employer has an appropriate policy document in place ground, which is obviously easy to remember. If you want to rely on that, you need to go through a process of documenting why is it necessary, what are we doing, what's the policy around that, how do we safeguard the rights of the individuals as employees versus our needs to do it. So it's weighing it up, it's similar to a data protection impact assessment. Another new and enhanced right under GDPR is the obligations if there's data breaches. So David alluded to the fact that there's been quite a lot of press about some big breaches recently, and outrage at the fact that people haven't disclosed it, and also that the law doesn't really have any teeth. GDPR is meant to change that. So now, if there is a breach of security and it leads to accidental or unlawful, unauthorised disclosure of personal data, you will, in certain circumstances, have to notify the ICO, which is our regulator. These situations where you have to notify are where it's going to result in a risk to the individual, so the employee, most likely in your context. And that could be because there's risk of discrimination from the disclosure, there's risk of financial loss if it was payroll data, bank account details, there's loss of confidentiality, there's damage to reputation. So I suspect most people will err on the side of caution, and if there is a breach, they will probably notify, because it appears, unless the data is completely benign, that it's likely to result in one of those. If it's extremely high risk, if you look at it and think, oh, you also need to notify the individuals. And what do you do if it's not a breach by you? So you've done everything right, and you've also vetted all your suppliers, but they come to you and say, we've breached. Well, firstly, you need to make sure they are going to come to you and say that. And so that goes back to looking at those third-party contracts and making sure that you've got obligations in there on your suppliers that they will not only comply with the GDPR and that they notify the ICO and they notify individuals if necessary, but they notify you so that you can manage the message with your employees internally, because you want to be able to control that situation rather than it appear that it's your fault but you've got no control over it. So what should you be doing right now? Because there's a lot out there in terms of, what are all the different steps to take. But actually, to get this process started, I think there's some quite simple first steps to take. Some of them may already be happening. So the first is that it just needs to be on the internal radar. So if it isn't, some of the role of HR is to raise this and say, what are we doing about it? Is there a committee? Should we get a committee together? Who's the privacy champion in your organisation? It should be someone senior. The GDPR expects proper engagement. It's not just a tick-boxing exercise. You also need to assess whether you need to appoint a data protection officer. David said earlier that that depends on what you do. Public authorities certainly will have to. If you are engaged in systematic or regular processing and monitoring, you will have to. If you are engaged in large-scale monitoring of health or criminal records checks, you will have to. If you're unsure, you're meant to go and check with the ICO, but you can do it voluntarily, and it may be that some people just take the view that if they're borderline, they do it voluntarily and don't go through the hoops. The next step is to, in a rewards context, look at what you process and why. So make sure that you've documented all the different types of data. Where does it come from? How do you hold it? Where does it go to? What does that involve? Does that involve a transfer outside of the EU? How long do you hold that data for? What's the purpose of the data? Why are you holding it? And the reason that that's really important is to show that you have complied, so some of it's evidential, but also the results of that audit will help you identify other fair processing situations so that you're not having to rely on consent. It will also tell you whether you're retaining documents too long and you may not be compliant, and you'll want to clean up your act and get rid of anything that's been hanging around and shouldn't have been, or anonymise it or pseudonymise it. Just make sure that you're going to be compliant by that May date. It also identifies where it's going to, so it might help you identify who those third parties are that you need to check the contractual rights with, or whether it's going to group companies that may not be within the EU, and you may need to consider how you affect that transfer outside of the EU going forward. You also need to review policies and procedures. So there's some obvious changes, like how you're going to deal with data portability, how are you going to deal with the right to withdraw consent, how are you going to deal with the right to be forgotten. But there's some wider issues in that data protection by design means that it should be flowing through to all your internal policies. You should be looking at them and thinking, well, who has access to that and why, and should there be restrictions? You also need to look at your contractual documentation, as I said, with third parties, and also what you get employees to sign when they participate in any reward, and why. And are you happy with the form of consent? Do you want to use it going forward? And if not, does it need to be amended? And then last, but probably most importantly, is to train everyone. Make sure the managers know, make sure the employees understand, and everybody is engaged and understands their obligations going forward. And if you do all of that, hopefully you won't go too far wrong. So, I can see I've got 3 minutes left, and we are very happy to take questions. Yes.
Wow. Now, some of you would have known that already, and for some of you will be going, what a lot to do before May. I think one of the questions is quite key. Does the government really think we're going to get this all done by May? But I'm not going to ask you that. I think that was a rhetorical question. We haven't got a lot of time, so in the time we've got, one that I thought but linked to today most strongly is, what are the GDPR implications of using employee data to target communication of benefits? So often here people would need age, are you married, have you got children, where do you live? There's all sorts of things that we've been talking about to make benefits more personalised.
Yeah, so I mean it's going to be definitely personal data. It's sometimes going to be sensitive personal data. And the data audit will establish, well, why are you asking those questions? If there's a reason for asking it, you then need to identify a fair reason for processing it and try and avoid consent. But if it's to tailor a benefit and you get their consent to use that data to get a more tailored benefit for them, then very explicit consent related to the benefit that you're offering is the way to go. But it needs to then make clear that they are able to withdraw as quickly as they give it. What happens if they want to be erased? What happens if they want to port everything? So you just need to have gone through the thought process of the policies around that as well.
Quick question. What constitutes anonymised data? Does using an employee ID number count?
Personal data it has to be identifiable, and The current law actually says that if you use an ID number and you can, by going and checking another list, then identify, that's still personal data. So my view, and it hasn't been tested under the GDPR yet, is that that won't be fully anonymised. So to be fully anonymised, it's just we've got a population that has these different people in it, but it doesn't link it back to anything that could identify the actual employee.
I only scratched the surface of all the questions, I'm afraid. There were quite a few coming in, but time's also up.
Feel free to email if anyone's. We put our emails on the slides.
I'll be able to put that slide back up again just for a few seconds if anybody wants to email either.
And we've also got a really good learner graphic that it's got the headline issues, but then you can click into the bits you're interested in, and it's got quite a short synopsis. So it's quite a good starting point. And if you want us to email you that, we'll just email it through, obviously free of charge.
Okay, it looks like it's tricky going back to slides when we've already... Oh, there we go. So if anybody wants to scribble that down. And at the same time, say a huge thank you on a very, very important topic. David,
thank you.